Hello and welcome to the next episode of the SILP podcast. Today, I am Rudra Athray, joined with my co-host Akshat Goyal and the guest for today, Professor Prabhash Ranjan. I would like to begin this podcast with a short introduction of our guest today. Professor Prabhash Ranjan is a professor and vice dean at the Jindal Global Law School. He has completed his PhD in law from King's College London, his LLM from the School of Oriental and African Studies, and his LLB from the University of Delhi. Professor Ranjan teaches and publishes in the area of international investment law and international trade law and has an extensive career as an academic in both these fields. He has been a member of the team that drafted the 260th report of the Law Commission of India on the 2015 draft model Indian Bilateral Investment Treaty and has also been invited by the Parliamentary Committee on External Affairs to depose as an expert witness on India and bilateral investment treaties. He has authored a book, India and Bilateral Investment Treaties, Refusal, Acceptance, and Backlash, published by the Oxford University Press in 2019. Additionally, he has published in several leading international journals across the world. Lastly, both Akshat and I have had the opportunity of attending one of the credit courses offered by Professor Ranjan very recently on investment treaty arbitration in India. Professor Ranjan, welcome to the podcast and thank you for being here today.
Thank you. It's an honor. Thank you.
Thank you so much, Professor Ranjan. Both in the course where you were teaching us, and I'm hoping in a conversation today, you have illuminated us in a number of ways, and opened our eyes not only about investment law, but also how linked India's history is with regards to its present stance and its present standing in international law as well. I wanted to understand, and I think something that our listeners will be really interested in as well is what was your inclination or motivation towards pursuing a degree and a career in international investment law? And did this inclination germinate in law school itself, and how did LLM or pursuing a master's degree in this particular field gravitate your interest?
Yeah. So thank you, Akshat. Thank you for that question. Uh, what generated my interest in international investment law? It did not happen when I was doing my LLB. It happened much later. So I had a degree in economics before I started studying law. So I consider myself a lapsed economist in that way. Now, after my first degree in law, after my first degree in economics, when I started studying law, I was obviously fascinated by the interaction between law and economics. Now, the interaction between law and economics takes place at several levels. In one way, even tort law, for example, would have interactions between law and economics. Now, it was in my final year when I opted for an elective course on international trade law. Was the first time that I got exposed to. I had studied international trade as an economic principle during my economics honors days at Delhi University, and then to look at the same issue from an international law point of view was quite fascinating. Till this time, I wasn't aware of international investment law. Forget developing an interest in it. And when I then started working after passing out from the law school at an organization by the name of Cuts International in Jaipur, it was there when I was exposed to international economic law more broadly, which included international investment. And then the 3 years that I spent at Cuts and then at Oxfam, where I was doing research and advocacy work on international trade, it is in these 3 years that I discovered about international investment law, so to speak. And while I started off as a trade lawyer, and I still sort of keep flirting with trade law as and when I get the opportunity. But while studying or while working on trade law, I realized that while there are people in India who are doing work on trade law. I couldn't find anyone who was looking at the international law part of foreign investment. And interestingly, all free trade agreements had a chapter on investment. So investment was very much a part of international trade. And as economists will tell you, that trade and investment actually go hand in hand. So you can't decouple trade from investment and vice versa. So then when I went for my masters to London, I was clear in my mind that I want to now study this subject and maybe write a dissertation. And that's how, while I was doing my LLM, and that's how I started working in this area. And I wrote my dissertation on India's investment treaties. Again, it was a struggle in those days to even find the text of the investment treaties that India had signed. The finance ministry, I asked an official from finance ministry, and he said these are classified documents. I said, how can a treaty be a classified document? But those were the days when it was difficult to find even the text of the treaty. But then during my LLM days at SOAS, thanks to Professor Peter Matlinsky, who was my supervisor, he played a crucial role in helping me understand the subject. And since then, I have been kind of wedded to this subject and have been working on this for last 15, 16 years.
Thank you so much for that answer, Professor Ranjan. It's very interesting to know that someone who has such an inspiring career in the field of investment law, the first 3 years of your life as a student, you were somebody who thought would come off or come out as a trade lawyer. And I think from your answer, something that I found exceptionally interesting was what you said about the fact that trade and international investment cannot be decoupled from one another. And that's something that brings me to my next question, which is while you were extensively involved in investment law and have started out as a trade lawyer, how do you think both these fields, both in practice as well as in the field of academics, converge and interface with one another?
Yeah, thank you, Rudra. But before I answer that question, I also want to make a comment about the law school where I studied and how different that law school is from the law school where you guys are studying, or from the 5-year law school. So I studied at the 3-year law school at Delhi University, which was good. We had some very good people to teach us, but it wasn't as competitive as say NUJS is, or a NALSAR is, or a NLS is. And I kind of learned that kind of competitive spirit when I joined NUJS as a faculty in 2007 after my LLM. So I'm sure a student at NUJS perhaps better would have been better aware about these things than a student at Delhi University. And therefore it took me some time to discover that there is something like this once I started working. Now, to come to your question about the linkages between trade and investment, as I said, basic economic theory tells us that trade and investment go hand in hand. You will rarely find an example of a country in history which followed a liberal international trading regime but didn't had a liberal international investment regime. So one of the reasons why countries want to attract foreign investment is because they want to project themselves as a base where production can take place, and then trade can take place. So therefore, just like trade and investment go hand in hand in economic theory, likewise, in my view, trade law and investment law also go hand in hand. So my point is that if any young student wants to make a career in this area of law, I think it would be a mistake to say that I'm going to focus just on investment, or I'm going to focus just on trade. At least not when you start off. You can do that super specialization a little later, but you need to look at international economic law more holistically, or more comprehensively. And this international economic law will then contain international trade law and international investment law. So while bulk of my research has been in international investment law, I've done some research in trade law as well. I've published papers in trade law as well. But I'll say if I write 8 papers in investment law, maybe I write 2 in trade law. but I have been teaching trade law for the last several years, and the fact that I teach trade law along with investment law has helped me immensely in my investment law research also. While no one can write papers in every area of trade or investment law, but if you want to become a good trade lawyer, you need to keep reading investment and vice versa. And therefore, for any young student listening to this who wants to make a career in this area, I'll say look at international economic law more broadly, with trade and investment going hand in hand. And once you have developed some expertise, some basic experience of 5 6 years, then maybe you could consider focusing more on one, and a little less on the other. But initially, it has to be both the subjects together.
Right. So, I found it extremely interesting. Firstly, how NEJS, even for like non-students and even for faculty, can be an atmosphere that inspires a competitive spirit or just reignites that fire. It's quite refreshing to hear that. But also something I wanted to know is, as you talked about this relation of working with international investment law and trade law and your path with it being interlinked with teaching, how exactly or like what about this field attracted you to academia of it, and how does you know the academia or the teaching bit of it relate to practicing international investment law, or help you in when you're advising, or recently when you were um advising on the India BIT models and so on and so forth. How does the academia bit of it help, or overlap or spill into the practice of this area of law?
Yeah, so the reason why I got attracted towards teaching this area of law is because I was always interested in making a career in research. I'll not say teaching to start with, but I always wanted to make a career in research, largely because I enjoy to read, write, etc. And also during my law school days, I happened to visit the Cesare, and I said I can't be doing litigation. So, but on a more thing is something which I enjoyed. Therefore, research came naturally, and since research came naturally, teaching was a logical extension, because just like trade and investment go hand in hand. Likewise, teaching and research also go hand in hand. If you do not teach and if you only research, then you are only talking to yourself. But if you teach along with your research, then you can go and bounce off your ideas to your students and tell them about few things here and there, and that actually helps in your own research. Now, if you look at India's law schools historically, uh, India has always produced, or well, some of our law schools have produced outstanding professors when it comes to public law. And when I say public law, I largely mean domestic public law in terms of constitutional law, administrative law, etc. But you will struggle to find law professors, well-known law professors in say commercial law, or in private law. Well, of course, international economic law in which I work is not really private law. It's also part of public international law. But you will not find too many professors in that area, at least people who have made a name for themselves. And therefore, it occurred to me that this is an area in which one should be working, because students are interested to study these topics, or students are interested to study these subjects, but perhaps there are not competent people teaching these subjects. So there is a void, or there is a vacuum which needs to be filled. And my thought process initially, if I go back to 2007 when I started my academic career, was precisely this, that this is a vacuum or a void which needs to be filled. Of course, no one can fill the void fully, but at least partially. And I could see at NUJS, when I started teaching, I could see that there were students who were interested in trade, investment, and stuff like this. It was not just constitution or administrative law or criminal law, but that they were not getting perhaps the right kind of motivation or direction or teaching. So from that standpoint, also I think that teaching in this area of law, which is a little different from say constitutional law, etc., is also important. And now things have become much better. I mean, now if we look at the law schools around, almost every law school offers a course on trade law. I'll not say the same for investment. The quality of the course, etc., of course, still needs to be improved, but at least there is someone teaching trade law, and trade law is being taught in law schools, and students are learning the subject. So that in itself, is a good start. But one has to build on it and take it forward, and ensure that we not only have people teaching trade law or investment law, but we have competent people teaching trade law and investment law. And that can only happen when competent people decide to pursue an academic career, which still remains a challenge in this part of the world.
Exactly. And Professor Ranjan, I just have a short follow up to that answer and the question that was asked by Akshat. When you talk about teaching investment law, right, one question that many students are potentially aspiring to have an academic career have is how would it contrast with practicing investment law in other fields that are not restricted to academics? Would it be possible for you to maybe enumerate a bit more on that regard?
Yeah, no, absolutely. Also sort of linking to Akshat's question,
Yes.
that how working as an academic helps you offer practical advice
Yes.
to the government, or even to say a client, or of course professors can't practice, but say to any other research organization, etc.
Yes.
I think it plays a very important role. One important aspect that is not emphasized in India enough is that no professional should be working in a silo. In India, unfortunately, all professionals work in silos. So you will rarely find practitioners interacting with academics, or academics interacting with practitioners. And it almost appears as if these two constituencies don't want to talk to each other. Now, I completely understand that there may be several aspects where the practitioner might have a superior approach just because of the practical insight of dealing with something on a daily basis. But likewise, there are many other aspects where the academic would have a far superior approach in comparison to a practitioner. A practitioner is something who may be able to give you a micro picture of, say, a particular case or of the issue involved. But the academic would be able to give you a macro picture, trying to, will be able to theorize and tell you that, if something is happening, what has led to this and what this will lead to. And I think that kind of input is also important. Now, when it comes to advising, say, the government, or advising, say, policy bodies, etc., it is not just the micro part which is important. It is also the macro part which is important.
Exactly.
Unfortunately, in India, we do not have successful academics. I mean, people who are seen by law students, for example, as quote unquote stars. In the sense that you see people in law firms, or amongst litigation. So if you want to make academic career an attractive proposition for young students, you need to tell them that this is not just about going to the class and lecturing to your students. There is also a lot that you can do outside that, and there is a lot in terms of the contribution that you can make by, say, advising the government, provided they are willing to take your advice, advising other think tanks, advising so many other bodies, being part of research projects, also helping the judiciary in certain matters. I mean, I have been, I obviously can't give details, but I have been part of processes where I have helped courts, nationally and internationally, to understand the point of law. Which perhaps they saw some value to go to an academic and not go to a practitioner. Now, these are the aspects which needs to be highlighted, and I feel that I was able to do this job because of a more solid theoretical footing, theoretical understanding of the subject, which, with due regard, you know, most of the practitioners might lack. But it's important that practitioners, academics, and everyone works together and doesn't work in silos.
Right. So I think, Dr. Ranjan, the working in silo, as you mentioned, is most apparent even when we look at, suppose, India's appointments to the ILC or other international law bodies, right? They are mostly diplomats who have little or no pedigree in international law, who are not scholars of international law, who are advising such bodies. So I definitely take a point at its conclusion. However, like taking a step back, what do you think would be the possible, say, avenues in international investment law that could be particularly interesting to up and coming students who are interested in this field? And what do you think are some things to keep in mind before you enter this field as a career, either as a practitioner or an academic? So, what do you think is firstly, interesting upcoming rather debates or areas of law within this particular system that could be interesting to students?
Yeah. So as we speak, the world is changing, and the neoliberal template of international investment law, which prevailed for more than 2 decades from early 1990s, is not the dominant template now. And countries are contesting, or countries are reacting to international investment law because they have experimented with the neoliberal template for almost 2 decades, and perhaps they are not satisfied with that template and they want to have a new template. Now, what should be this new template? There is no one answer to this, and I think students need to understand, or the listeners need to understand, that when you're looking at a particular subject, and what the broad contours of that subject can be going into the future, you need to tell yourself that there is no one way, or there is no one sort of answer to this. uh, just to give you a couple of examples. So, if you look at the work of scholars like Anthea Roberts, for example, who talk of a geo-economic narrative on globalization, international economic law. Now, this geo-economic narrative mainly focuses, or has security or national security as a very important element of international economic. We are seeing this in context of trade, and we are seeing this in context of investment as well. So, for example, the significance that now countries are attaching, both developed and developing, to foreign investment screening. That is, we will screen investment and decide whether whether it will affect our national security or not affect our national security, and then let the investor come in. These dimensions are getting strengthened. So there is the geo-economic narrative of international economic law, which students have to keep in mind. The other narrative is, recently World Trade Review, the famous journal published by WTO and Cambridge University Press, they have come up with a special issue which is titled as, or which looks at the theme of domesticating international investment law. And this is very, very fascinating because there are several examples where countries are not signing investment treaties, at least not with the same spirit with which they were doing 2 decades back.
Yes.
And there are examples, say, if we look at India's example as well, where India is not so gung ho about investment treaties. So the argument is that, is India domesticating in international investment law? In other words, is India telling the foreign investors that from now on it will be the domestic law that will regulate your investment, or that will be the most important instrument and not international law? And if this is true, then in a way we are going back to the 70s and the 80s, when domestic law used to be the most important framework. So to conclude this point, I'll say there are two narratives that students should focus on. First is the geo-economic narrative on international economic law and how it is affecting international investment law, and the other is this backlash against investment law, which some people call as domesticating international investment law. Some people even go to the extent of saying this as delegalization of international relations in general, and of international economic relations in particular, or dejudicialization. For example, the complete paralysis at the WTO's dispute settlement body. A backlash against investment treaty arbitration. So all this points to what some people call as dejudicialization of the international economy. So I think it's important for students to keep these larger narratives, these meta narratives in mind while they study, the interpretation of a particular provision given by the arbitration tribunal. At times I find that students get so lost in the positivist framework, which of course they need to be. I mean, you need to know the law well, right?
Yeah.
But you also need to be aware of the meta narratives, going along, because that would then help you to get the micro and the macro, which I mentioned earlier as well.
Right, so I think this would be the best time to segue into our next segment where we talk about international investment law and in relation to India as well. So, as you mentioned about domesticating international investment law and delegalizing investment law, that's something that India is also doing. Something that you spoke about in your book as well. That from 2011, India's foreign investment initiatives, took steps to liberalize its policies and regulations, a term that you also referred to as backlash. Additionally, 2011, as we know, was also the year, what you termed as a watershed year for Indian BIT program, with the White Industries Arbitral Award being passed against India. How exactly, in your opinion, do you think was a gap created in 2011 with the circumstance surrounding international investment law and bilateral investment treaties that India's economic policy and legal policy was with regards to foreign investment? And additionally, can we also term the White Industries Award as a tipping point for ISDS claims against India?
Yeah, so for me, the world is divided into two parts: pre-white industries and post-white industries. I mean, I'll say my career is also kind of divided into two parts in that sense. So, white industries had a big fallout not just on India's investment treaty program but also on my academic career. But to answer your question about on India's investment treaty program, I'll say yes, it was a tipping point, but it was not just the white industries case. Let's assume that we just had the white industries case, and which India lost, and the amount involved was not very big, and India was happy to pay that amount off and sort of finish that matter. Now let's assume that nothing had happened, no other claim had come after that. Then maybe the kind of churning that we are seeing today, or that we have seen in the last 5-6 years, perhaps we might not have seen that. So it was white industries followed by a slew of ISDS claims being brought against India, one after the other. Now, one can always argue that why something like this happened, why something like this did not happen a decade earlier, why it started happening from 2011 onward. But we all know that there's always a time for something to happen, and it is quite possible that the White Industries Award gave the foreign investors the opportunity to kind of use something like this against India. Perhaps they did not explore that opportunity that well. And then after the White Industries case, we had Vodafone and Kane Energy and the Devas cases, etc., etc. And that all culminated into India's reaction, in terms of India's very strong reaction. Now, whether this amounts to domestication of international investment law, I am not very sure vis-a-vis India, in the sense that uh, you know how would we understand domestication of international investment law? South Africa is an excellent example of this. So South Africa, for example, said that we will not sign investment treaties, but we will put in those standards that are generally found in investment treaties. We'll put those standards as part of our domestic law. So you have a South African, law on protection of foreign investment, etc. And that is a typical candidate for this theory of domestication of international investment law. We don't see that in India as yet. So we have domestic laws for protection of foreign investment, and these laws are scattered, into different legislation. So there's no one kind of law which we can point to and say that this is about protection of foreign investment. And therefore, whether India is a good example of domestication, I'm not very sure. But yes, it depends on how you define domestication. If you look at domestication as just saying no to international law and using domestic law as the framework, then maybe yes, India would also qualify. But if you're using this to show that there is no international law but a domestic legislation which provides for protection of foreign investment, perhaps India hasn't reached that stage as yet. But I am personally not very comfortable with this idea, and I don't know if I can speak about this now, or maybe we can talk about it later. But briefly, uh, you know, I personally feel that India is accepting international law when it comes to international trade. So India is now very keen to sign these FTAs one after the other. Till 2020, we were averse to FTAs, but post 2020, our approach has changed, and we now want to sign one FTA after the other. So we have no problems in accepting international law as regards trade is concerned, but we have a problem in accepting international law as regards investment. Now, this I think is a artificial wedge. This is again the decoupling that I talked about initially.
Yes.
Just like you can't decouple trade and investment in the economic sense. Likewise, in my view, you can't decouple trade and investment in international, under international law. And India is experimenting with this, not consciously. It might be happening for other reasons, but as an academic, when I look at it, this is how I try to theorize it. This decoupling is happening where we're accepting international law on trade but not on investment, and this, I guess, is might lead to problems in the future.
Yes, Professor Ranjan, as you said that, firstly, the White Industries Award has played a significant impact or a significant role when you're talking about jurisprudence vis-a-vis international investment law. And at the same time, you also touched upon the changing dynamic and the changing approach adopted by India in recent times, which has been giving rise to a domino effect when it comes to international investment law as well as international trade law to a great extent. Which brings me to a follow up question. And this is a topic that has been in discussion quite often when you talk about the White Industries Award, which is the effective means standard for enforcement of rights, which was first postulated in India's context and applied in the White Industries Award. So, did the same serve as a wake up call for the Indian judiciary vis a vis the undue delays in processing ISDS? And in furtherance of this question, I have a follow up, which is how viable do you think the reforms that emerged in the Indian jurisprudence in response to the same post the White Industries Award were in the greater scheme of things?
So the effective means test. The reason why India lost the white industries case was because of a particular interpretation of the effective means standard, and the tribunal held that India hasn't treated the Australian investor at par with the Kuwaiti investor, from where this effective means standard was imported. Now, whether this has led to any improvement in the working of the judiciary, it's difficult to say. That has to be empirically examined. But there are instances where one can find revocations of the white industries case. So, for example, if you look at the Law Commission report, the Law Commission report which was submitted, and when Justice A.P. Shah was the chairperson of the Law Commission, there was a report submitted on the amendment to the Arbitration Conciliation Act. And in that report, you will find that there is a clear reference that the Law Commission makes to the white industries case. Basically making a case for amending the Arbitration Conciliation Act so as to reduce the interference of the judiciary in the process of arbitration. And in making that case, they actually document the white industries case. Now, I've talked about this in one of my papers. This, I think, is an example where investment treaty arbitration or ISDS mechanism has actually served uh, quote unquote as a reform, as a at least as a point of reform for domestic judiciary and for how judiciary needs to pull up its socks and get its act together. But whether the judiciary has been able to do that or not, I can't answer that question. I have my doubts, because if we look at the pendency of cases, they have definitely increased. Yes, one can say that the approach of the judiciary towards arbitration has changed, and it has become less interfering and more differential. But then, as we all know, that we just live from one good decision to another bad decision, and a bad decision can then set the clock back. I hope it doesn't happen, but one can never be sure. But a more important point here is that, in India, whenever we have a problem, instead of strengthening the existing institution, we often think of creating something new. So, we want to settle commercial disputes, so let's come up with commercial courts, or let's create some extra tribunal. I'm not very, I have a problem with this kind of approach, because this kind of approach then means that you can't improve the existing thing, and therefore you want to create something new. But what is the guarantee that the new institution or the new court structure or whatever you create will deliver results? Because this court structure is also going to function in the same ecosystem in which your previous institutions or other mechanisms haven't worked. So instead of strengthening those mechanisms and finding out the reasons why they are not functioning, we always want to create, something new, or something more spectacular, which will help us capture grand headlines. But beyond that, it doesn't serve much purpose. And the last point I want to make on this issue is, again, specifically on the question of arbitration. When we talk of arbitration in India, most of the people don't even have treaty arbitration in their mind. Most of the people talk of arbitration only in terms of commercial arbitration. So recently, I don't know if you must have heard, the Delhi arbitration weekend, which is ongoing.
Yes.
And all the debates, which the Delhi International Arbitration Center sort of is organizing. All the debates circle around the same kind of issues which are typical in commercial arbitration. There's nothing that one can find on treaty arbitration. And that again points to a mindset where arbitration is seen as a private law, commercial kind of activity, without understanding that there is another aspect to that which also needs to be dealt with. And the reason for this is, of course, I mean, I have written a lot of articles on this, making this point. But I think it's important that more and more people need to focus on this, which perhaps is not happening.
Right, sir. So just taking your two responses as a cumulative. First, as you speak about the DIAC mindset being quite distant from investment arbitration, and secondly, the mechanism of inventive judiciary, as you call it, that India has. Do you think these could be potentially factors that are driving this artificial wedge of decoupling international investment law and international trade law in India? Whereas we see international investment law being highly regulated in India because there is less focus on dispute mechanisms in India itself, whereas the same is not true for international trade law.
Uh, Akshat, I think on this point, the decoupling is not because of the actions of the judiciary. The decoupling is more because of the actions of the executive, or because of the thought process of the executive. Uh, I'll give you an example. If you look at the recent FTAs that India has signed, if you look at the FTA that India signed with Australia, it's not a full-fledged FTA, but whatever limited form of FTA that we have, or the FTA that we signed with UAE or Mauritius, in the last couple of years, these three FTAs are the ones that we have signed. None of them contain a chapter on investment, which is very, very striking. I have made this point in my writings, and this is very important. The reason being, if you compare this with the FTAs that India had signed in 2000s, If you compare this with India's FTAs with Korea, Malaysia, Japan, Singapore, all these FTAs were signed in mid 2000s, early 2010. All those FTAs had had a chapter on investment protection. These FTAs don't have a chapter on investment. And the way India UK FTA negotiations are going, it appears that it will also not have a chapter on investment. Now, this points to there's a pattern, right? This is not just a one-off thing, right? And this points to some kind of thought process within the government that we don't want to include investment as part of the trade umbrella or trade agreement. So the decoupling that I'm talking about is happening more because of the thinking of the executive, and even this thinking is not articulated clearly, right? There's no position paper that one can go to find out the reasons. I mean, I fully understand that the government might think that we want to decouple it for A, B, C reasons. Fine, please write out those reasons. I mean, please tell what those reasons are, rather than leaving all of this within the realm of speculation. So I think that I'll not give credit to the judiciary for this, but I think it's more because of the actions of the executive. Judiciary, with all due regard to our judges, is largely clueless about investment treaty arbitration. Let me say this bluntly. Most of our judges have limited understanding of investment treaty arbitration, and largely because they have limited understanding of international law. And the point that you made earlier about how India nominates diplomats and all these people to bodies like ILC, or how India nominates judges to ICJ, or I'm writing a piece. I'll go back and work on the piece after our conversation, where I'm showing that how India has nominated retired Supreme Court judges as its arbitrators in investment treaty arbitration. So out of 14 cases that we have, for which data is available, in almost 50% of the cases, India has nominated a retired Supreme Court judge or a High Court judge as an arbitrator. Now, apart from the fact that this might be a post-retirement, benefit being given because it's investment treaty arbitration and the sovereign is appointing the judge. So this contributes to that debate, and it also contributes to the debate that how India can't look beyond retired judges, when it comes to making these appointments, and therefore this kind of, it's all at one level you may think that they are different to each other, but at another level they all are related, and this is largely because of a failure to fully understand and grasp the subject.
Right. So just an offshoot to that question, your criticism of India's executive with regards to the FTA is not the only criticism, so to speak, that the Indian executive has with regards to international investment law in India, right? Considering the fact that we see in a number of decisions decided against India was because the Indian executive was held to have acted in bad faith or due to problematic legislative decrees such as the cancellation of the spectrum licenses or the retrospective application of income tax as was done in 2012 judgment. So how exactly or what exactly have been these backlash policy developments and changes that the Indian government has incorporated post these arbitral decisions? And do we see the same being reflective even in the model BIT that India introduced in 2016?
Oh yeah, absolutely. So I mean, as far as the data goes, there are about 10 cases in which we have a decision. Roughly about 10 cases. Out of these 10 cases, 6 or 7 have gone against India, and in 3 cases, I think India has prevailed over the investor. So it's not that India has lost all the cases; India has also won a few cases. Now, my thesis has always been that a large number of these cases, I'll not say all, but a large number of these cases came against India because of India's own misdeeds or policy failures or whatever you may like to call it. And instead of correcting those failures, India has actually doubled down on the road of sort of distancing itself from those aspects. So just to give you some quick examples, if we look at the model BIT, it doesn't contain the MFN provision, and this is a direct fallout of the white industries case, because we lost the white industries case on account of the MFN provision. Now, as I've argued in my writings, and I also discussed this when I was teaching the course to all of you, is that the correct remedy to this was to have a limited MFN provision and not to have the MFN provision. So this is an example of learning the wrong lesson. Likewise, if you look at the model BIT, it excludes taxation measures completely. In fact, it makes taxation measures non-justiciable. Now, this again is a direct fallout of Vodafone and Kane Energy cases. Again, not recognizing that these cases came up because you changed the law retroactively. And if you had not done that, then both these cases would not have arisen in the first place. So, my point is, and maybe I'm in a minority. Other people perhaps are okay with what has happened. My point is that India should have learned the right lesson from these disputes and should have incorporated that into its model bilateral investment treaty. So if you look at my PhD thesis and my work before white industries, I always argued that India's investment treaties are very neoliberal in their approach, where they give a lot to the investor without preserving anything for the state, and there needs to be a balance that needs to be struck. So the pendulum was somewhere at this end, and I argued it needs to be brought in the middle. The government took this advice a little too seriously and taken it to the other end. So as a result, what is happening is that now you have provisions which only protect the state's right to regulate and give very little to the investor. So again, now my academic endeavor is to, sort of make a point that we need to bring this pendulum back in the middle. Because if you don't do that, then you will face difficulties. I mean, we got the model BIT in late 2015, early 2016. 7 years have passed. I mean, how many investment treaties have we signed? Only with Belarus, Kyrgyzstan, and countries which are not major exporters of capital to India. And all the countries which are major exporters of capital, they have misgivings about India's model investment treaty. So, which means that this is not going anywhere, and it needs to be revisited. I don't know if your listeners know about this. The Parliamentary Committee on External Affairs, you mentioned in my introduction that I deposed as an expert witness before this committee. This committee has also recommended, it's a parliamentary committee. This committee has also recommended India to revisit its model BIT. And it has recommended that there is value in India negotiating investment treaties. So there is, I mean, apart from silly academics like me, there is also a parliamentary report which says the same thing. And therefore, I hope the government would take this advice and would course correct.
Exactly. And just building upon what you said, Professor Ranjan, in an environment where we see the absence of crucial provisions such as the MFN provisions, as well as the system of appointing justices to these forums, do you think that India has adopted a very reactionary approach to the evolution of its investment law jurisprudence? And how do you think 10 years down the line we should go about bringing about change as well as helping this jurisprudence to evolve for the better? And as a supplementary question to that, because you're such an experienced academician, what role do you think institutions of education play in this change and in this evolution?
So, Rudra, several questions there, but to sort of try to answer some of them, I think let me try to answer them in the reverse order. What role institutions can play. I think that's very important.
Yes.
And well, as an academic, I always tell to myself that maybe the article that I write no one reads, but it's still important to keep writing them, because even if no one is reading it, at least you are generating record, and at least in the future you will say, oh, there was someone who said this even then. So you can kind of put your hand up and say that, yeah, I did this, right? So at least history will remember you more more fondly, if not the contemporary times or your contemporary peers. Uh, but so the role that the educational institutions can play is that they need to constantly keep coming out with cutting edge research. And the best way to counter disinformation or misinformation is by more and more information and more analysis. And a lot of this research, if possible, I mean, lawyers are not trained in empirical research, I know, but if this research could be empirically grounded, then it becomes even more better to make your case. So what educational institutions have to do is, first, I'll say two things. First, they need to build the capacity of the society by training their lawyers well in these subjects. I teach this course at Jindal, and this semester about 55 students have opted for it, although it's an elective course which should not have more than 30 or 5 students. So I can clearly see that there is a high level of interest. Even when I taught this at NUJS, the number of students who opted for this was very high. So there is an interest among students to study this subject. So education institutions have to build on their competence, and then the education institutions, through their academics or through their students, have to continuously come out with cutting edge research, which questions the government, tells about the alternatives which are possible. It is possible that no one will read it. It is possible that motives might be attributed, but nonetheless, it's important that you keep doing it on a continuous basis.
And
Right. So, yeah, Rudra, go ahead.
yeah, thank you. I'm just circling back to that one question, which is when it comes to harbinging that evolution, which would be in the form of, as I said, uh, having a more inclusive and a more holistic judicial as well as a more holistic legislative approach to international law. Do you think there are some objective pointers that India as a country needs to look out for?
So when you say objective pointers, can you elaborate a little on that?
Exactly. An example of this is, as you said in your book, that a partial adoption of an MFN provision, which is something that India as a country should very objectively
Okay.
work towards. Do you think there are
Okay.
any other such provisions, other such steps that
Right.
India?
No. Yes. Right. Right. No. There are quite a few. There are quite a few provisions. So, for example, if you look at the investment chapter in the EU Canada CETA, the Comprehensive Economic and Trade Agreement between European Union and Canada, the investment chapter there, in my view, has several such objective sort of markers, that can be used. So MFN is one, and they have a curtailed and a restricted and a narrow definition of MFN. So what this does is that while it retains the benefits of MFN, at the same time it kind of gets rid of the excesses of MFN by ensuring that it can't be broadly interpreted to for disruptive treaty shopping. Likewise, they also define in a way what legitimate expectations mean. And this again is important because legitimate expectations have been a part of fair and equitable treatment provision and subject to a lot of controversy. So if you can actually define what it actually means, you are curbing the discretion of the arbitrators, and giving them clear indicators of what or when can it be said that the investors' expectations have been believed. So there are quite a few such examples that one can look at, and in my book and in my writings, I have advocated for it. But for all of this to happen, there first has to be a consensus that we need to go down that path. Currently, the consensus seems to be that the path on which we need to walk is the path of domestication. So although we have a model, but that model is as good as not having a model. So the path is domestication. But if we are convinced that no, this path is not the right one to walk on, and we need to move on to the next path, then one can always look at several such templates and several such objective identifiers.
Yes, sir, that is indeed very insightful. And with that, we've reached the end of our podcast with Professor Dr. Prabhash Ranjan. So, thank you so much for being a part of this podcast and really answering mine and Akshat's questions about investment arbitration in India with such depth and expertise. I'm sure that this podcast and the discussion we've had for some time now is going to be very, very helpful for somebody interested in this field of law and intending to build and forge a career in the same. Thank you. And for all our listeners, thank you for sticking around, and we shall see you in our next episode of the SILP podcast. This has been me, Rudra Athray, and my co host Akshat Goyal, interviewing and speaking to Professor Dr. Prabhash Ranjan.